Okay, 2 minutes past. We'll just keep admitting people as we go, but I think we'll just get straight into it. Hello, everybody. Thank you for joining us. My name is Elise. I am from Villamanta Disability Rights Legal Service. And I am very pleased to be here co-presenting with some fantastic people from Intrepidus Law, who I will introduce to you all very shortly. As you're all aware, we're here to talk about the NDIS bill, and it's happening quickly. We don't have a lot of time to get our heads around all of the big changes and to provide some response to the government if we wish to do so. So the purpose of today's session is to really provide some key information about what's proposed in this NDIS bill, and then allow everyone the opportunity to ask any questions and just share some opinions, stories, whatever you wish. It's a community forum, but I will just say that we are recording this session. So please be mindful of not sharing anything personal, private that you don't feel comfortable with being recorded. Okay. All right. So I just have to figure out, because I've got multiple screens happening, how to change my screen. Does that still look okay, everyone? Have I changed screen okay?
Yeah, that's perfect.
Perfect. Thank you. Okay, I will start with our acknowledgement. As always, I would like to acknowledge the traditional custodians of this land, the Wadawurrung people of the Kulin Nation. That's where the Villamanta office is placed. We recognise their continued connection to land, water and community. We pay our respects to elders past and present, and we extend that respect to any First Nations people here today. We would also like to acknowledge all people with disabilities who continue to lead and inspire our work. Okay, a little bit of housekeeping that we always have to go through. You can turn on automatic captioning. You can do this by clicking the 3 dots at the bottom of your screen. If you have any issues with that, just raise your hand or put a comment in the chat and someone can give you some more detailed instructions. You can ask questions using the Q&A section or the chat. We'll have someone monitoring that, but we'll also have time to answer questions either as we go along, depending on how we're tracking for time, or at the end. There'll be an opportunity, whoa, I just lost my screen, sorry. There will be an opportunity to speak at the end. As I said, you're welcome to do that by putting something in the chat or raising your little hand if you wish to actually speak and share with the group. Otherwise, please keep your microphone muted as we go through this presentation. And as I said, it will be recorded and hopefully we'll put it up on our YouTube channel quite quickly. All right, that was key housekeeping done. As I said, my name is Elise. I'm the senior lawyer from Villamanta Disability Rights Legal Service. We are a community legal centre down in Victoria. And my 2 fantastic co-presenters today are from Intrepidus Law, Kelly Wilkins, who is a lawyer there, and Trinity Ford, who is a law clerk, and I understand leads the policy work at Intrepidus with the principal. So 2 fantastic and very knowledgeable presenters here with me today, and I think we'll have a fantastic session, hopefully.
Thanks, Elise. It's Trinity, absolutely. Looking forward to it.
Perfect. Great, thanks, Trinity. Okay, little disclaimer, last one, I promise. This is a lot. This is a lot of information. There's a lot of changes. It's coming with not a lot of time for us to really take the time that we would like to get our heads across it, process it. So if you feel overwhelmed at any point, please do not stay. You can take a breather, leave the meeting, take care of yourself. That's the most important thing. There are other sessions that we're running at Villamanta that other organisations are running, and we can put those details in the chat for you. So you can jump on to another session if you reach your limit today, that's absolutely fine. We acknowledge this is a difficult time, but we're all in this together, and we're trying to look out for each other. And if nothing else, hopefully taking this time to come together brings with it a bit of a feeling of solidarity that we're in this together, okay? All right, beautiful. So this is high-level agenda that we'll be running through today. It's not an exhaustive coverage of all of the changes in the bill. We would be here for a lot longer if we were to do that, but we're really trying to focus on the key changes that we think people should know about. All right, enough of my talking. I will hand you over to Kelly.
Thank you, Elise, and welcome everybody. Sorry, I've just unmuted and my dog has barked, so apologies for background noise. All right, so just to begin with, for a bit of context, this is a really informative slide. So as you can see on this slide, there is a pathway to follow in order for a bill to become law, which is set out very well on your screen. As we're all aware, the reason we're all here is due to the Minister introducing the NDIS bill to Parliament, on the 13th of May 2026. It's been through the first and second reading and has now been referred to the Senate inquiry. I'm so sorry, just choked on my own saliva. What a moment for it. Mark Butler has said he wants this to become law by 30 June 2026 to achieve his budget savings. So the government are moving quite fast to push this through. At the moment, it's important to note this is not law yet. Be very aware of that. This is not law. And there are steps that must be followed for this bill to become law, as shown on your screen. It is usually a lengthy process. However, the government is pushing hard to fast track this process. I'm so sorry. The Senate inquiry is allowing the public to make submissions only until the 29th of May, which is next Friday. With that small time frame for submissions, it's important to get educated and act now to stop this bill. We'll talk more about the submissions and how you can contribute at the end of this session.
My section, it's Trinity speaking. Before we get into the meat of the bill, so to speak, we wanted to give a little bit of a rundown on the minister's powers here because they're potentially the most extreme and concerning part of the bill, but also the part that's the most up in the air. And as Kelly was just saying, none of this has become law yet. Parliament is still going through scrutiny, and the minister is asking for pretty extraordinary powers. So we're hoping that if anything gets cut out of this bill, it's a lot of the stuff I'm going to speak to here. Before I get into it, I just wanted to echo acknowledgements of country and pay respects to Wongal elders in Eora Nation who are hosting me here. So, a little example of some of the areas where the minister's powers come in. Most of you are across the way that supports can be deemed reasonable and necessary, and that's how they end up in our plans. We'll talk you through in a moment some of the changes that are being proposed to that process. Comparatively, they're kind of smaller than some of the changes that would flow from the minister's powers. So the bill would allow the minister to set maximum amounts or intensities or ratios of supports for certain classes of participants or classes of support. So it could be no more than, $1,000 on equine therapy, or that you're not allowed to have 2-to-1 supports in a certain environment. Once a plan has worked out what's reasonable and necessary and what's the maximum that they are allowed to put in the plan, if it's reasonable and necessary but you're over, sorry, out of luck, according to the bill, then they go and translate those into the price guide maximum dollars. Then there's a second way that the minister can tweak with how that calculation happens by then applying a percentage by which that would be reduced. Only for certain categories of supports, they've indicated that they plan to do this for social, community, and economic participation. But the way that the bill is worded is that it could apply quite a bit broader. Might have the next slide. Thanks, Elise. Another example of some of the ministerial powers that are concerning a lot of us is what are called 50A renewals. So It's very similar to how the NDIA are already rolling over plans. You might get towards the end of your plan, a 12-month plan usually, and then they're like, oh, look, we'll just roll it over. We'll top it up with the same sort of supports. We'll give it to you for another 12 months. We don't really want to speak to you about it. The bill formalizes that process, but with a few little additions that might seem benign at first. And if they're implemented in a benign way, would be fine, but we don't know how the minister will implement these and future ministers all the way down the track. So it would allow the minister at that point of renewing a plan or rolling over a plan to do so, put in the same things that are in the old plan, but with additions. The minister can specify what those alterations should be, rather, or a mechanism for the agency to work out how to do those alterations. That would be at the point of rollover. But there's also a mechanism for them to change your plan like midstream. So they can identify a circumstance that might activate, for example, a life event, or perhaps incorrect invoicing. If we're sort of speculating here, we don't know the extent to which these powers might apply. And the agency could then use that trigger of something changing in your life, or they think that you're doing the wrong thing maybe, to then trigger some sort of change in your plan, which might be maybe locking up some of the money or changing the plan management, perhaps. Like this is really like an area of speculation because the minister would be allowed to make a lot of changes. The most concerning part of this is that these are not renewable decisions. Section 50A guarantees some appeal rights, but not those most important bits where the minister can start tweaking around with things. So we wanted to start off with perhaps the heaviest piece of information, with that reminder that this is not yet law and that it's so important for us all to speak up and protest, write to your members of parliament and explain how you feel about these sort of changes. Yeah, I think we might go to the next slide. Thanks, Elise. Yeah, and as I was just saying, they let the government of the day sort of change this game day to day. So we're going to talk you through the how the actual fixed parts of the Act and how those changes are proposed. But keep in mind that a lot of this is a fluid territory. I think it's over to you, Elise, now, is it? Yeah.
It is. Thanks so much, Shinidi. Sorry, I'm just having to navigate a couple of screens. So if it pauses for a second, that's just me trying to figure out where my mouse is. Okay, so the next section that we'll be going through is the access provisions. And for anyone who's unfamiliar, when we use the term access, we're looking at the eligibility criteria for people to gain entry onto the NDIS. So we're starting with a little comparison. Currently, the NDIS Act says that functional capacity is a term that it's used, but it's not defined. There is a test of substantially reduced functional capacity, but that's applied on a case-by-case basis. The NDIA have 21 days to make a decision after an application is made. So you put in your application to the NDIA saying, I think I meet the access criteria. They have to give you a decision, yes or no, within 21 days. These are key things that are being changed in the bill. Functional capacity is defined as a term for future rulemaking. We'll go into that in a bit more detail in a moment. There will be rules that effectively limit who can be considered for access before applying the legislative test. The NDIA will have 90 days to make a decision. That's right, about 4 times as much time the NDIA has to make that decision. So that's an extra 70 or so days that someone is waiting without supports to hear whether they'll be accepted or not. And also the definition of permanence is being changed. Okay, looking first at the functional capacity definition. So the definition in the bill is that a person's functional capacity in relation to an activity is the person's ability to undertake the activity without assistance from other people, assistive technology, or modifications, and in a context that excludes, as far as possible, the impact of the person's environmental and personal circumstances. There is also scope for rules to make provision for determining any matter for the purposes of that subsection. So that's pretty broad. On the face of it, this functional capacity definition may be what people assumed the term to mean. However, that allowance for that definition to be changed or read, interpreted in a different way, dependent on rules about who can be made a participant and who can't, that is a key difference. And the rules can be anything related to this definition, but there are some specific examples that have been included in the bill, which are, some of the examples. There can be methods or criteria applied regarding functional capacity. There can be classifications or thresholds about what type or how much. Think potentially levels of autism spectrum disorder. And there can be things that the rules can require some things to be taken into account and some other things that can't. So it's pretty broad that there can be sweeping rules about access. Now, this does align with the comments that Minister Butler has made that 160,000 people are anticipated to be removed from the NDIS, and these rules about who can remain or join the NDIS for the first time are an important aspect of how these numbers will be limited. Okay, so now we're moving on to permanency. And I can see there has already been a question in the chat about getting these slides. They will be sent out, so that's why we've got a lot to get through. So I'm just trying to keep it moving, but don't worry if you feel like you haven't quite caught something or want to refer back, you will have these slides available to you afterwards. Okay, so the change in permanency is a big one. A person will be required to have undertaken all appropriate treatments. Appropriate treatments has been defined as evidence-based. It has to be reliably expected to materially improve the person's condition and is regularly undertaken in Australia. This applies regardless of the person's circumstances, which may include that they can't afford it or they live in remote Australia and they can't get to the clinic that's across the country. That doesn't matter. That's not a factor that will allow the NDIA to consider that the condition is permanent, and that is a departure from the case law. It's also concerning that material has not been defined. What exactly is a material impact? We've already seen lots of frustration from medical professionals who've had to repeatedly state the condition is permanent and then being asked again and again about particular treatments. There is a team within the NDIA who provide technical advice, and we have seen them develop guidelines about conditions like fibromyalgia and ME/CFS and the treatments they believe people should prove that they have tried, but they are not necessarily medical staff. And people are individuals, and these technical advisors cannot possibly know what is right for every individual. Okay, and there are also changes being made to the early intervention requirements. The early intervention criteria is being changed from benefit the person by mitigating or alleviating the impact of the person's impairment to benefit the person by reducing the impact of the person's impairment. This has the potential to delay access for people with degenerative conditions until the point they meet the disability requirements, which potentially reduce their quality of life. So instead of being able to get onto the scheme, get early intervention supports, they have to essentially wait until the impact has already happened, their condition has worsened, and then they'll be able to get some support potentially. Okay, so that's a really quick run through of some of the changes for the access provisions. So now we'll move on to the planning and impairments changes. So I will pass back to Trinity.
Thanks, Elise. I might just go straight on to the next slide. I'll speak to how planning works, but also particularly in the context of impairments. So meet Al. Al is our little hypothetical case study. Al is blind and has access to the NDIS on that basis. Al also has a range of other conditions, which means that they do not use, that they need to use a wheelchair when they leave the house. The NDIA do not agree that these conditions meet access. Al also has a psychosocial disability, and the NDIA do not agree that that condition meets access. So we're going to do on the next slide a comparison of how that would work under the current scheme versus how the bill proposes to change that. So the current act, there are these little in the legislation, at the end of a section, it'll have a little bit that says note and then explains how to interpret or understand some of the powers of the act. So the way that works means that the planner has to take into account some of Al's non-access disabilities to the extent that they have to see Al as a full person. And as well as considering the vision impairment for which they got access to the scheme. Next slide, thanks. So, as I said, the current act, we've got those notes. You also, if in seeking a support, you need to demonstrate to prove that it's reasonable and necessary and can go into your plan. The current act says that it needs to be the need for that support needs to arise from an impairment for which you have access to the scheme. The way that the bill would change some of this is that the notes are just gone. That same section of section 34(1)AA would also insert the word directly. Now, we're not sure how much that really changes section 34. It might take some case law to work out some of this. But the, I think, stated intention of it is to move towards a narrower definition where you need to explain that it's the direct and primary cause, that for Al, their blindness is the reason why they need to use a wheelchair, which is hard to do under the current act, and makes that a lot harder under the proposed amendments. It also excludes impairments that are caused by car accidents and work-related injuries where there are schemes for this. There's also a power for the minister to add other schemes onto those exclusions. So we'll need to see how that plays out if the bill passes in its current form. Next slide, thanks. So there are some other cost-cutting considerations which planners need to consider. A lot of this is in the proposed changes to section 34, into the other paragraphs of that test for determining what's reasonable and necessary support that can go into your plan. So planners will now need to consider whether there are cheaper alternatives to the support. Maybe instead of a wheelchair, Al can have a support worker drive them places. The change here is that it no longer requires the support to be able to achieve the same outcome. You'd have a pretty good shot at saying support worker can't replace a wheelchair under the old bill, under the old act, the current act. Still definitely ways to make that argument with the current bill, but we're going to need to see how some of the case law plays out. Other considerations are, would leasing be cheaper than buying? That's in the current act, but with some changes that tighten up how planners need to make those considerations. Planners are also required to consider what research and evidence there is of the proposed support's effectiveness. Again, that's in section 34, but with some more tightened and rigid rules around that now that have been brought up into the legislation themselves. And finally, maybe the biggest change to section 34 is some presumptions around parental responsibility, which will also be really interesting to see how these play out. Yeah, next slide, thanks. I think that's you, Kelly.
That is, thank you, Trinity. So we're going on to talk about the philosophy of the scheme. I feel like this is really important in relation to, I guess, looking at what these changes are going to mean in what we are looking at with the objects and the principles of the Act. So if I can go to the next slide. So we've got section 3, which talks about the objects of the Act. So we've got on there, the current Act is to provide reasonable and necessary supports, including early intervention supports for participants in the NDIS. The changes, as we can see out there in red, is so far as is consistent with financial stability of the scheme. So essentially the changes are saying that we'll provide supports, but only if we can afford it. The second part of that is that the wording, reasonable and necessary supports, has been omitted for NDIS supports. So what this says is it's essentially another way that the scheme seems to be moving away from assessing an individual's support needs based on reasonable and necessary criteria to categorising people into groups of impairments and supports. Sorry, if I can go to the next slide. Okay, there we go, yeah. So section 31 talks about the principles relating to plans. So we can see that on the screen, we've got individualised, directed by participants. We've got the right of the participants to exercise control over his or her own life, maximise the choice and independence, tailored and flexible responses. Now, these principles work the same way as the objects of the Act. They're not independent rights, but what they do is explain what Parliament intended the law to achieve, and in this case, what plans would look like. So there's lots of great stuff in here about how planning was expected to work for participants. Like I've said, it's to be individualised, directed by participants, for participants to maintain their control over their own lives with choice and independence. And if we can go to the next slide. This isn't such a great one. So as we can see, this section has been removed entirely from the bill. So with the exception of subparagraph C, A, and F, which have been included in other sections, but mostly these principles have been stripped out completely. Now, whilst at law this doesn't have much of an effect, it indicates to us how the government now sees the relationship between the scheme and its participants by reducing the choice and control and individualised aspects of the scheme. And that's probably the most concerning for a lot of people here today. I think we're moving on to back to you, Elise.
I think this one's Trinity, and I'll just flag that the time flies, so we're having fun. So we are at 2:30 already.
Let's whiz through it.
Great. Thank you.
Thank you. All right. Yes, I'm speaking to a little bit of a cluster here. First up, planning reassessments. So we've spoken through a little bit before about how planning works, but the step before that is whether you're allowed to have a reassessment or not, whether you're allowed to make the argument that you need more supports in your plan. So for the longest time in the NDIS, that was a very easy process to pop a change of circumstances form in, and then off you go. And then we're having a conversation with the agency and they're saying, no, you can't have that. You can't have that support. Okay, that one's fair enough. This act really seeks to tighten that down. The government has said that the reason that they've wanted to prevent people getting reassessments unless they need them is because most reassessments end up in an increased plan rather than a decreased plan, though plenty of people have had their plans cut that way. So the current act, I think I've spoken to most of that. Importantly, it's a reviewable decision, and yeah, changes as far as the bill goes. Instead of the 21 days that the agency has to consider whether or not you can be reassessed, they've now got 90 days. And there's a change in the deemed refusal as well. So under the old act, the current act, I've got to not talk so pessimistically about it. Under the current act, if the agency don't get back to you after that 21 days, then it's deemed to be a no, which for lawyers like Kelly and Elise and folks like me who are nearly a lawyer, that's really useful because you've got a decision that then you can go and take on to the next step. That's pulled out of the act. The agency has 90 days to sort of have a bit of a think about it and get around to it at some point, but no deemed refusal. There's still ways to, if they don't make a decision, to push them, but they're more difficult. The other main sort of cluster of changes is what you need to prove in order to get your plan reassessed. I forget if we've got that on the next slide or if I'll speak to that just quickly off the top of my head. No, if you want to pop back quickly, you now need to demonstrate yeah, as it says there, certain conditions apply, which is largely that you've had a significant and ongoing change to your functional capacity or to your environment, which is defined in kind of quite tight ways. So you need to explain that, like, my support needs have increased because of my body or my environment is sort of it in a nutshell. And yeah, I mean, I think that's enough on that page. Okay, suspensions. I'm going to start off with the good news that this is largely reviewable decisions, but the agency does have a new power that if they've been unable to contact you for 90 days, they can suspend your plan. There's another power in there that lets them cancel your plan as well. These are decisions which, if the agency gets it wrong, there's a mechanism to step through. But we're concerned about whether that's watertight enough, because that's a really, like, exiting someone from the scheme is obviously a really big consideration. The CEO or the delegate who is then progressing to a suspension needs to satisfy themselves that they've made reasonable attempts to contact you and that they still can't reach you. A lot of how that plays out will depend on a combo of how what the agency feels is reasonable, but then also how lawyers taking it through the tribunal and courts are able to define that definition of reasonable. That's why it's so important to have appeal rights, because then we can fix problems that are in it, that are going to happen. Thanks, Elise. Payments and claiming. So Intrepidus Law has made a lot of submissions to parliamentary inquiries, and our principal, Belinda Kokonovska, was recently testifying to the Joint Committee on Public Accounts and Audits on a lot of this area. So the There are some changes to this area of the Act as well. At a high level, claims need to be made within 2 years. On the current Act, and the bill would change that to claims need to be made within 90 days. The bill also requires participants and nominees to keep records of claims and payments for 3 years or 5 years, depending on which of those people they are. Thanks. I think that's good for that slide. There are some big changes to plan management as well. We've known that these were coming. The government wants to be able to more tightly control the pool of people who are allowed to be a plan manager. So they've been going down a process of making registration mandatory for plan managers for a little while. The bill progresses that a little bit further. What it actually means on the ground is that we'll have a much smaller pool of plan managers. If you're with a small one, you might need to change to one of the government's sort of chosen providers of plan management. And then there are some other changes that are a little bit by the by, but that's the main bit that I want to leave everybody with.
Thanks, Trinity. Okay, we're almost at the end of the formal presentation. Thanks everyone for hanging in there with us. I will speak briefly about the automation. The NDIA will be able to automate certain decisions. For the moment, they are focused on plan production and payments. So this goes back to when Trinity mentioned that the potential for, say, 20% of all community participation funding just being wiped from participants' plans. That is referred to as a support determination. And this is a decision that the Minister for the NDIS can simply just make under this bill. The concern is, what information is that automation relying on? How is it being applied? Why can't the participants see how that works? Can they review it? All of these questions really raise concerns about the procedural fairness of applying automation. It does get into robo-debt territory, which is a concern for all of us, and quite possibly it raises a lot of questions for each participant. Why was this applied to me? Was it because of a particular disability I have that's recorded on my system? Potentially, if you haven't received an impairment notice, you don't even know which impairment is recognised on the NDIA system. And who knows, sometimes participants may have received an impairment notice and that would have been magically changed by the agency. We have seen that happen from time to time, that things get swapped and participants aren't informed. So the possibility of things being automatically done to participants' plans is concerning without knowing how that's applied, what information is being relied upon. It's a big question mark, but there is broad power for automation to be, I guess, utilised by the agency. Okay, and our last little bit, I'll pass over to Kelly.
Thank you. So this is where we talk about how you can get involved. So we may as well just jump into that next slide. So I think it's pretty fair to say that some of us feel like the community doesn't get it. We don't get it. We need to talk to the people around us. We need to educate people within our world of how this bill and how these proposed changes are going to actually impact everyone, not just the disability community. I think that if you are able to, it's good to make submissions, even if that submission is just to say that this is being pushed through too quickly and we need to slow down and give the disability community and the entire community enough time to object to this being rushed through. You can contact your federal MP, tell them your concerns. Local newspapers love a good story. Talk to journos who you have connections with. Talk to your disability representatives organisations, or join one. and join in the online discussions and campaigns. So, you know, get behind the organisations that are supporting our community. We've got organisations like Every Australian Counts, Disabled People Against Cuts, People with Disability Australia, and the Australian Neurodivergent Parents Association, among many others, who are all working really hard to provide the community with information and bring awareness to what quite frankly will have catastrophic impact on our community. So we need to make our voices loud and unapologetic and do everything we can to oppose this bill making its way into legislation. So we encourage you, contact your federal MP and make your complaint known. If we go to the next slide, Villamanta have kindly provided access to some time slots with law students for next week. For those who are wanting to make a submission, they're offering to help you write that submission. So I think Elise is going to put details about how to put that into a chat. But at the end of the day, we just need to be loud about this, and we need to make sure that we do everything we can to bring attention to what this will do and how this will impact our community and take away that choice and control and individualisation of our plans.
Great, thanks, Kelly. And just to confirm for everyone's understanding, the law students, they will be available Tuesday, Wednesday, and they're really there to just help you get it down, write it down into a document. It's not within their scope to say provide advice about, oh yeah, this is really great, you should put this in or this in. It's for those people that know what they want to say but just can't type it out and can't send it off. So it's just that practical support. So I will send through details in an email to all attendees after this session if you are interested in taking up that support. Okay, we've got through the formal part of the presentation. I will stop sharing my screen so I can actually see you all. If I can work out how to do that. Just need to navigate to a different screen. Okay, perfect. Hopefully that has worked. Yep, okay, great. All right, Ryan, you have been incredibly patient. I can see you've had your hand up. Go ahead and unmute yourself if you'd like.
Oh, g'day. Sorry, my name's Ryan. Thanks for putting this on. It's really good. I don't know. I've just written a couple of questions down. I'll just go through it quickly. It may be something you've spoken about. I've been on NDIS since 2020. And look, it's just been a nightmare. I'm constantly having changes, change of circumstances, and I've currently got a review in. Last year I had support, which wasn't enough. And unfortunately, what I heard the NDIS do is that when you put a change circumstances or review, they'll take something off you. So that's what's happened to me. I only have support now for about 2 weeks left because of the funding's been 5 yearly. So that amount does not cover my existing support, which I don't understand. I was originally on it for fibromyalgia as well, but I was basically taken off. No notice. It was just, it's treatable. And my question to them was, okay, if it's treatable, what do I do? I still don't know. So I'm suffering pretty much daily with it. I just wanted to check with that access. I think it was 21 days. So I've got a review in that will be 21 days tomorrow. So I haven't heard. I've put in a letter to my local MP. And just in regards, I just wanted to share maybe things that I've heard that they're going to take my support coordinator off me. They are basically looking at not covering people with major depression, not covering psychologists. They'll let you do an assessment, and that's gone. A lot of travel with supports. they'll only do if it's a medical emergency. So this is all the stuff I've heard. Yeah, and look, I know there's a lot of people. I'll just sort of leave it there, but thank you. If you can answer anything, it'd be great.
Thanks, Ryan. It's Trinity speaking. We can't speak too much to the individual circumstances of your case, but it's a lot of stuff that we hear across at Intrepidus Law as well as in a lot of our previous work. Especially the yeah, I'm sorry to hear that your change of circumstance form resulted in a cut in funding. You're not the only one. And yeah, that's probably all I can say, but best of luck. Yeah.
Thank you.
Okay, the next person on my screen with their hand up is Lisa.
Thanks, Elise. I work in Sydney at a school for specific purposes, doing a lot of post-school transition support with families. And up until now, we felt confident when requesting a plan change based on change of circumstances and asking for a reassessment, referring back to leaving school as being a significant life stage change or transition. However, we're now really concerned that the bill is saying that unscheduled plan reassessments will be for unanticipated changes only, and major life stage change transition of leaving school is very much anticipated. And so this really big, beautiful thing that parents felt confident to use to self-advocate with their children, they're feeling really threatened that that is now lost. Can you talk to that change to help a whole bunch of Year 12 families?
The change of circumstances is being significantly narrowed, absolutely. Trinity, did you want to speak to this as that kind of fell within your scope?
Yeah, happy to. We're going to need to see again how a lot of this plays out in the tribunals and the courts. One thing that we're really interested in is unanticipated when. Is it at the time that we're doing the previous, like designing that previous plan that the person is now wanting to depart from?
Okay.
The other tension here is that it's not the agency's job to future-proof a plan about future circumstances that it can't see. What I think we would want to see is that anything that can be put into a plan that's, foreseeable, if we can put something into a plan about like needing to think ahead about what that foreseeable change in somebody's transition away from schooling will look like, then great. There's a lot of reasons why you might not be able to do that if it's a little bit too. If it's a 5-year plan and that's going to happen in year 4, like that's quite a stretch. What we'd want to say is that there's some parity here of if we decided that that's a little bit too far to know what it's like, that then you should get to have a second go. For that should be a reason to get a plan reassessment. That should be relevantly. But like that's a systemic policy way of thinking about this, and like obviously not legal advice. That's not something that we can give in this forum. Just one way that we're thinking about how we hope to see this bill play out into something that's actually workable. Thanks, Lisa.
Thanks, Trinity. I think that was a really helpful response. Helen, did you want to go next?
Hi, thank you. I just wanted to get some clarification on my interpretation of what some changes might be to see if I have to be concerned about these things. So with the changes that the minister can make rules like reduce social and community participation funding for everybody down to 7 hours a week, which is what the figure they've mentioned equates to roughly. Where people are funded because they basically need supervision, which is my family's case. You know, we have so much funding under assistance with daily living, so much sitting under community access. But no matter what it's called, we need the funding for that number of hours a day. Otherwise, someone's going to be left unsupervised, that it's not safe for them to be left alone. Is that going to be Am I right to be concerned that if the rules made about social and community participation across the board, there's not going to be anybody looking at that plan saying, oops, that person has 24/7 one-to-one support and can't be left alone for the 30 hours a week of funding we've just taken off them?
Yeah, great question, Helen. The bill does say that the agency have to have regard for participants' safety. That's nice that they have regard. But the concern is if it is an automation of 20% off anyone who falls within this bucket, then that's what's going to happen. So whether or not they will have different classifications for if people have a tick box of this is a person with significant needs that needs 24-hour support, maybe that will be a particular classification and they won't touch that group for specific decisions. It's all a bit of an unknown at this point, but the bill would allow that to potentially just be a blanket decision. Yeah.
Yeah. Okay, thank you.
All right. Remy?
Hi. I'm just coming from the an activist perspective, just for clarity. But I was just wondering what sort of legal recourse, if any, exists for any harm that is caused as a result of people losing their care or potentially even we could anticipate deaths occurring pretty directly because of this, unfortunately. Not to trigger anybody here. What sort of avenues do we have from a legal perspective to sort of press that as an injustice?
Yeah, big question. And unfortunately, it's not something that's necessarily just been brought up in relation to this bill. It's not a new concept of people saying, well, I haven't received the funding or I've been put in a really bad position because of the agency's decision-making processes. I'm not sure if either one of my panelists want to jump in specifically on this point. The most important thing right now that we can do is to specify exactly what the concerns are about this is what I'm worried will happen, that these are the potential consequences and they can't get any more serious. So now is the time to put that in writing, make noise, go to whoever you can. That's the best thing that can happen right now. Trini, I can see you've unmuted, so I will.
Yeah. Kelly, I'm wondering, I mean, I agree. We've got to focus on making sure that only good legislation passes the Parliament. Once it's on the statute book, if we end up there, then like lawyers are going to try to pick it apart. You know, I mean, I don't know, Kelly, what you think about not to be speculating on any of those options, but just generally how lawyers try to make sense of or get things read down by courts if there's concerns about a piece of legislation being bad.
Look, I think that the thing we need to do is identify that risk. That's a really, really good question. And at the end of the day, we can't just go sue the NDIS. So we've just got to identify risk and be really clear about that, and just make sure that we're advocating in that way. Unfortunately, it's probably not the answer everyone wants to hear. And we're right, it is happening. It's very triggering. And I think that it's just about advocating and identifying risk.
Thank you.
Great.
Elise, this is
Thanks.
just Julia
Kim?
here. Sorry to butt in. I've just
Oh.
had there's a number
Go
of
for
people asking in the chat of how this might impact people who are at the tribunal currently. Number of people asking that, so I thought I would just pass that along. Thank you.
Thank you, voice from above, Julia. That is a fantastic question. Sorry, was there someone else?
Oh, sorry, just waiting.
Sorry, Kim,
Yeah.
you're next on the list. But I will respect.
Yeah.
Sorry, did you have a similar question, Kim?
No, not really, but if you want to answer the administrative tribunal one first, because that is very important.
Okay, yeah, thank you. I think that's a good idea, as we do have many people asking that in the chat apparently. Great question. So there is a provision in the bill that talks about essentially these new plans with these new principles will be created once the current plan is reaches its end, essentially. So current participants with current plans, those plans will remain in place until the agency approves a new plan in line with this new legislation. Kelly, did you have any comment that you wanted to make on this point? I'm getting sick of my own voice.
Look, at the moment, unfortunately, there's a bit of and I think Trinity has said this before, there's a bit of a wait and see how this plays out. We don't know exactly what parts of the bill will be passed, how much of it, things like that. If a bill is passed and you have a current ART matter, then the law is the law and the law applies at the time that it applies. So if there's things that are changed and there's a lot of talk about what will happen with your new plan, your new plan will be subject to what is the law at the time. So hopefully we'll wait and see how it pans out. But at this point in time, it's a really difficult question to answer.
Yes, unfortunately, there's, like a lot of things with this bill, there's still a lot of uncertainty, and there's, to refer back to the graphic at the very start of this presentation, we're at the early stage still. This isn't a law. We're doing this consultation, so there is still a lot of detail to be worked out, unfortunately, which no doubt comes with a lot of anxiety, unfortunately. Okay. We have hit 3 o'clock, but I can see we've still got a lot of hands up. So respecting people's time, absolutely fine. If you've blocked out 2 till 3 and you need to head off, that's fine. I'm happy to hang around for a little bit longer because we have a lot of hands still up, but also noting that there are multiple forums going on throughout this week. We at Villamanta, we're hosting another one this Friday from 4 o'clock until 5 o'clock. So if you have to head off, but you want to continue the conversation or you want to ask some questions, have a look at our event this Friday if you can make it. And there's also an event happening for disabled people against cuts and Every Australian Counts. So there's lots of forums, lots of opportunity to ask questions and share your opinions over the next week and a half. Reminder that we have until next Friday to make any submissions. Okay, I'll pass over to Kim now. Thank you for waiting patiently, Kim.
That's okay. My question is, I did actually put it in the chat, but I just wanted to touch on it while I had all you wonderful legal peeps here. It's a little bit current bill, new bill, current act, new bill question, and that is sort of touching on what the first gentleman spoke about, that they had a disability accepted, etc., and the emphasis that there is going to be on impairment notices and moving away from diagnostic. What is the current situation on adding a disability to the scheme? Lots of people believe that they can add a disability or they can, and then do a review on it. But my understanding is that it's not a reviewable decision, but yet the reviewable decision is of if you challenge the impairment notice. Can you speak to that a little? Because it's a very confusing thing in the community. right now, let alone going into a new bill that's talking about changing all of those criteria around it. But people are believing they're accepted for a certain number of disabilities or certain types of disabilities, trying to get disabilities added and then being knocked back for them. Thank you.
Yeah, great question, Kim. Trinity, do you want? Yeah, happy to. You're absolutely correct. This is a question that comes up very commonly. And right now, it is that impairment notice that is the reviewable decision. You simply saying that you want to add a new impairment to a participant record, that in and of itself is not a reviewable decision. And yes, it is confusing because people don't always know what impairment has been recognised. So that's number one, is trying to confirm which impairment has been recognised. And sometimes you may even need to do some information requests from the agency, because it can be confusing, and sometimes records can be changed for no apparent reason. So number one, it's really great to confirm which impairment is recognised by the agency. And then if there are additional impairments that you want recognised, it's important to consider what are the supports that you're really thinking to be approved that relate to that disability. You wouldn't simply want an impairment to be recognised just for the sake of it. But say if you are on the scheme for a physical impairment, but you want supports that are directly related to, say, a psychosocial impairment, then it is understandable that you would want that impairment recognised, but you would have to come at it through seeking those supports to be added, because the standalone of trying to get the impairment recognised isn't necessarily currently a reviewable decision.
If I can jump in quickly on a narrow point, it's Trinity speaking. Yep. Often when you're dealing with the NDIA at the front end, you get a bunch of different answers. One of the things that we find really helpful through the administrative review tribunal process is that you start talking to people who do these sort of questions day in, day out. One of the first things that we do when we've got a case before the tribunal is exactly that: work out what the actual current access impairments are. And then I think, Elise, you've handled that great. Thank you.
Okay, I'm flagging. I'm not sure we're going to get through everyone today. I'm sorry. I think we've got time for maybe a couple more, and then unfortunately we'll have to wrap it up for the day. Andrew, you're next on my screen.
Hi, can you hear me?
Sure can.
So it's a really good segue that we're talking about impairments. So my question is about how this legislation may impact people who have been to the tribunal previously to get certain impairments recognized under Section 24, and how the changes in legislation may affect those people. We know that in the law, there's a principle of double jeopardy. So things that have already been litigated once presumably will not have to get litigated or iterated again. But I know of several people, including myself, who had to go to the tribunal previously to have multiple impairments recognized under Section 24, and yet have had the agency have issues with implementing those tribunal decisions. They'd sometimes cite the Harmon principle as a reason why they haven't uploaded certain files, or they would have inconsistencies in some of their correspondence, whereby sometimes they'd recognize those impairments, and other times they would not recognize them until you've provided them with proof that you've been to the tribunal previously and gotten them recognized. So keen to get feedback on how this legislation may impact people who've already been to the tribunal to get the impairments recognized, noting that the additions to Section 24 were I think provisions that were in, say, NDIS operating guidance materials, but not legislation per se. Thank you.
Great question. I'll throw it open to either of my co-presenters, otherwise I'm happy to respond.
Look, I'd just probably say, Andrew, I appreciate the question. It's a complex question. It's probably a question where it's on the individual. And so you'd almost need to seek legal advice because it depends on the individual circumstances. So it's not really a question that can probably be broadly answered. Unfortunately, it would depend on the individual circumstances. I think it's really important to understand that the law is the law as it stands now. This is not law yet. So we need to see what's going to happen with this bill and how it will play out. So a lot of the questions, unfortunately, we wouldn't be able to answer today until we see how this plays out.
I would only add that when there are changes to what the access criteria are, and the agency does have power to reassess any participant's eligibility, if the access criteria have changed, there is the potential for the agency to consider, well, the tribunal found that you met the previous access criteria. What do we think right now with the current or potentially future access criteria if it changes? There is that potential, unfortunately. Okay, I think we'll have to have one last question, and I'm sorry to the people that are still waiting. We could be here all day, unfortunately, but I will send out the details for the other forums as well. And I'm sorry, but there's just so much to get through. Tanya, do you have a question?
Yes, I have a permanent disability. I've got MS. I've been on the NDIS for about 7.5, 8 years. I don't take prescription medication for my permanent disability. And with the new changes proposed, the government are wanting participants to try all forms of treatment and medications available in Australia to gain access and to remain on the scheme. Is that a breach of human rights?
Big question. Throwing in the big H word. Go for it, Trinity.
Look, there are a few bits in your question that touch on your individual circumstances, which, as I've said, we're not going to be able to go towards today. But the overlap of human rights with the NDIS is a really interesting concept. It's an ordinary piece of legislation which implements Australia's treaty obligations under the Conventions on the Rights of People with Disability, which is a human rights document. So there's one argument that the further and further away that the bill gets from the CRPD, that there are human rights implications in a negative way for that.
Okay, thank you.
Thanks, Tanya. And as my colleague has just helpfully put in the chat, sorry to anyone that any questions we couldn't get to today, please pop them in the chat or send it by email if you would like to Villamanta, and we will respond to the extent we can. And I will, as I said, send out details for the other forums happening over the next week and a bit. Thank you everyone for attending. It was great to see so many people engaged in this really important discussion. Thank you again to Trinity and Kelly. Fantastic to work with you on this. And take care of yourself, everyone.
Everyone, stay safe.
All right. Thanks, everyone.
Thanks, everyone.
Bye.